Say, for example, if someone is self-employed, so in that case, I mean, is it the same or how does it work? So say like someone is
So,
self-employed.
before that, I would like to tell our viewers that there is a deadline. So the loss of income and the furlough has to be before 1st of January 2021. But I believe Home Office will update their guidance again.
Good evening, viewers. Thank you so much for watching and sharing my live show. Please keep doing that as it helps me to be motivated and builds my confidence level to cover this show. Please ask your questions and our legal advisors will try their best to answer all your questions. I'm Aminul Islam, the host and producer of this show, and your legal advisor is a legal advice show. Today, I would like to introduce you with our guest, Mr. M. Shafi, who's a practice solicitor. Hello.
Hi, thank you, Mr. Amin. Thank you for having me on your show.
How are you?
Yeah, I'm good. Thank you. Thank you. And you?
Yeah, I'm very good.
I'm so sorry. I think it's been fixed now.
Yeah, it's fixed now. It's fixed now, yes. So yeah, how are you doing? Thank you so much for coming to my live show.
And I'm delighted to be on your show, and I will try my best to answer all the questions our viewer may have, and try to assist as much as I can.
Thank you, thank you. So, as this is your first live with us.
Yes, this is the first live year.
Okay, you've been watching our previous live shows.
Yeah, I did, and it is a great pleasure that you try to give more information to our viewers and to help them, in order to get, some sort of advice from us. It's really a great job that you have been doing.
Thank you so much. I'm getting info. I'm getting. I mean, from the background, from the back end, they're saying that there is a problem with our sound. So they're trying to fix it.
I can hear you clearly.
Hello, Mr. Shafi, can you hear me?
Yeah, I can hear you.
Yeah, sorry, viewers. There was a problem with our sound, so the technician are trying to resolve the issue. I think it's probably now. Yeah, it's okay now. Yes. So yeah, so let us start our. I mean, it's already been like 6 minutes. Sorry for the late. As viewers, Mr. Shafi is a practice solicitor, and this is his first live show. So yes. So Mr. Shafi, I mean, what would you like to discuss today? Would you like to go with the phone calls or?
Either way, we can discuss about the current situation in terms of financial requirement for those who are being infected because of COVID-19 pandemic. So
Yes.
we can discuss about this, and also if you have any questions, then we can
Yes.
discuss about any particular aspects as well.
Thank you. Thank you so much. We will also discuss the 10 years lawful residency. So the applicants who've been refused and been into 10 years lawful residency, they applied and they got refused. So we will discuss that. And let us answer the calls because I can see there are callers. So let us answer the calls and then we
no
will
problem.
discuss that.
No problem.
Yeah. So let us go with the first caller.
So we will discuss that. And
hello, caller. Hello.
Hello.
Hello. Hi.
Yeah. Hi.
No problem. No problem.
So let us go with the first caller.
Hello.
Yeah. Hi. Can you hear me?
Yeah. Can you hear me? If you can please.
Yes, I can.
You can please mute the actual video which you are watching, so that will help us.
Oh yeah, I just removed that. Yes, yes,
okay.
I removed that.
Thank you, thank you. Yeah, how are you doing?
Yeah, thanks for answering my call. My name is Ahmed.
Okay, Ahmed.
And
yes.
I came to UK in 2002 in September, and I sought asylum.
Okay.
And then my case was refused. In 2007, I left the country voluntarily. And I returned home on my own expenses. So my brother was here as well, but he had documents. So while I was going back home, I left my credit cards, bank cards, everything to one of our housemate, as my brother was on holiday. So when he come back, so he will hand over the cards, everything, bank cards to him. And in 2011, I came back to UK as a Tier 4 student. And 2012, I changed my visa to spouse visa.
Okay.
And now I got my ILR.
Yep.
And my question is, when I left in 2007 and hand over my credit card, bank cards, everything to my housemate, when my brother came back in 2007, so that guy was disappeared from home and he used the bank cards and everything. So now I don't know to which company or to whom what I owed. So my question is, will that affect my naturalization application when I apply now for naturalization?
Okay. So basically, I believe you got married to a British citizen, so you can make an application for naturalization after residing 3 years. And the problem is you need to satisfy good character requirement under Section 6, subsection 2 of Nationality Act 1981. So when they consider good character requirement, they will consider your immigration background as well. So I believe you were in the UK in 2007. That means you have already passed 10 years, 10 years from that day. So
yes,
from 17, so 10 years, that should be fine. But now question remain about your credit card. If there was any claim against you in terms of any unpaid debt, you would have received a county court judgment from county court saying that they owe money or you owe money to them. Have you ever received any documents from anyone?
No. I haven't.
Okay.
My brother, when he was here from 2007 till 11, I was not here. So my brother said that he received some letters, but he returned the letters back to them that the person is not here. But when I come back, still up to date, I did not receive any letter from anybody.
So did you try to contact anybody, any of the bank or the credit card provider?
No. He did not try to contact anybody.
So look, if there is an unpaid debt and if there is a CCJ, then there is a problem. Okay, so the clear guidance in terms of this sort of scenario. So if you are reckless in terms of having any loan from anyone, then you will be liable. But if there was such case, why didn't you go to police and make a complaint about that your card was used by someone else while you were outside of the UK? Did you do any sort of thing like that?
No, I haven't done anything like that. But when I come back to the UK, I came on the same name as it was before. But when I came here, then some of the friends, he suggested me that if you are blacklisted, then you can change your name with the deed pool, and then you can open the bank accounts. And that's what I did at that time. I did deed pool, and I just correct my name as it was wrong at the first as well. So I corrected my name. I opened the bank accounts. I bought 2 times car from Toyota, for example, on Halal Finance. And there was no problem in that.
Basically, you are not using the name that you used previously for your credit card, isn't it?
Sorry, say again?
So the name you are using currently, right? The same
Yes.
name you did not you used when you obtain credit card from the credit card provider, isn't it?
No. At that time, my name spelling was different, and now the
Different.
spelling is different.
So I think there will be a potential problem. There is a claim against you. Maybe they couldn't trace you because they are not aware of your current address. So you can do one thing.
So
You can
the problem is I don't know to whom should I contact or how can I find out the CCJ. I did check the CCJ online on my previous name and previous address when I left the country in 2007, and there was no CCJ, nothing on my name. It was clear.
Okay, then I think then you should be fine. You should be fine. But what you should have done, you should have made a complaint to the police that your card was used by someone else, and you could have got some kind of documentation from police. And
I mean, they would provide you.
It was my lack of experience actually.
Yeah,
that's why I haven't done that.
They will provide you a reference number, from the police.
So the best thing, the best way you can deal with your matter is if you submit an application, right? You have to give an explanation of your previous situation in terms of credit card and all this. So if the Home Office found anything against you, then you will be less likely you will be penalized for that, because if you give an explanation beforehand, and if you don't give an explanation or if you don't disclose this information, then your application will be refused and you will be barred for 10 years. You won't be able to make any application for naturalization.
Okay. Even this was in 2007, and now it's nearly 14 years from that. Still, they will be able to check 14 years back and check the credit cards and stuff.
There are some other aspects, because you are out of the country, your card was used, and if there is a debt, that you have to go. So, for example, if you have a CCJ, county court judgment against you, you have to comply with that. You have to pay the debt, or you have to come to an arrangement to pay the debt. So you didn't do that. So sure. I believe if it was the case, then it is in their system, and they can look into it, and they can find this information that you had outstanding debt. Right, even though it happened 14 years ago. But if there is an unpaid debt for 6 years, normally no one claim, or people can't claim, because there is a limitation act is there where you can't claim for an unpaid debt after 6 years.
Okay. So now I need to, when I do my application for naturalization, in a cover letter, I need to give this all details that what happened.
Yeah, of course. And you also mention your previous name and give some sort of information.
Yeah, the previous names I already mentioned. Yeah, I mentioned that in every application that I made to the Home Office, and I submitted my deed poll with that as well.
Okay, so you have to provide the same documents and try to give an explanation about the situation you had when you left the country. And
is there any way or possibility that I can find out if there is any CCJ on my name? So how can I find out that?
I think if you try to contact county court, they maybe, I'm not pretty much sure, but I need to look into it. They can find some sort of information against you, or if you do a credit check, then you can find some of the information from there. For example,
I did the credit check, and credit check shows clear. It says my credit score is very high.
Then it should be clear. It should be okay. Maybe that the person you are suspecting that that person used your credit card. Maybe the case that he didn't use at all. So you don't know exactly what actually happened. So is there any outstanding payment when you left the UK? Was there any outstanding payment for you to make on your credit card?
Hello? I think caller got disconnected.
Yeah. So the best way forward is you make an application with an explanation. Hopefully, the Home Office will consider it. And as you have checked that there is no CCJ or county court judgment against you, so you should be okay.
Thank you, Mr. Shafi. Well, related to this question, I would like to ask. So, if someone is having CCJ, does that affect indefinite leave or if someone wants to apply for like British naturalization, does that affect their
Yeah,
application?
it affects in some extent. So if you look into the guidance, they clearly say, if you have a CCJ, there are some compliance you need to do. So if someone receives a CCJ, if that person make the payment within 28 days, then basically the CCJ is clear from his record. But there is a time frame as well. So some people get bankrupt. So then when this sort of thing happens, so the Home Office will consider whether there is whether that person was reckless in terms of having a huge amount of loan. For example, if I have an income of £10,000 in a year, and if I try to, for example, it's not a bank, so they're not checking whether my affordability to pay it back. Maybe I can get from another business having like a product of worth of £15,000. So they didn't consider that whether I would be able to pay or not. So if this is the case, the Home Office will consider whether I was reckless. So if my income is less than what I basically go from the company or business, then they would consider me as a reckless person, because then they from outside they understand that I wouldn't be able to pay that much of money. So they consider it. But the best way to deal with this sort of thing is giving all the information to the Home Office and let them to make a decision on it.
Thank you so much. Another question is, say if someone has got debt, but he's paying like say like credit card has been withdrawn, but no county court judgment. So in that case, does that affect or does?
No, it doesn't affect at all. It doesn't. If anyone goes to the debt management scheme, paying the debt slowly, like for example, if I have a less income and if I try to pay it by like paying £5 per month, it's not a problem at all.
Okay. And say like if someone got like, I mean I've read the guidance, but still obviously your practice solicitor, you got more experience. So on behalf of members, I've seen many questions on the group. If say for example, if someone is having like points on his driving license, does that affect the applications, any kind of applications? ILR?
Yeah. So if you look into the guidance or AN guidance, they clearly say you don't need to mention it. In some extent, you don't need to mention it. But I always advise my client to mention it. But there is a provision that if someone is a persistent offender, then there is a serious thing. So it depends on the situation. If someone persistent offender means the person is re-offend again within a very short period of time, or getting penalty for that, huge penalty like for more than £200, then there is a problem. You have to disclose it. So it depends on the situation. So if there is a minor, for example, parking ticket, for example, someone go into Bog Junction and go a ticket, that's absolutely fine. It's not going to cause any serious problem. If I'm doing, like for example, speeding, it's a crime. Basically, I'm reckless driver. So in this case, I have to mention it, but it's not going to draw any adverse influence in the application. Yes.
Thank you so much, Mr. Shafi. So let us answer a call, and then we'll come back to the discussion. I mean, we'll discuss about the financial requirement, which is affecting the current people under the COVID-19. So we'll just connect a call. The current people under the COVID-19. Hello, caller, you there? Hello.
Hello.
Hello, good evening.
Hi, good evening.
Hi, how are you?
I'm good, thank you. I would like to ask a question.
Yeah, sure. Before that, I would like to request you, I believe you're watching our live. If you can kindly mute our live, so that will help us to understand your question. Yes.
I am, okay.
Yes. It's much better. So, yes, so what's your question?
Okay. I have applied for indefinite leave to remain, okay. Or refugee protection, 5 years. I've sent my application June 17, 2020.
Okay.
and I've sent my they've taken my fingerprints and supporting documents on 22 July on that
Okay.
year 2020. I haven't got any response yet. I've finished 7 months. I've tried to contact the Home Office. They're not responding to my letters. I have an emergency. My mom is not feeling well,
Okay.
and my two children are back home. They are British. I wanted to get them back, but I can't travel.
Okay.
I told them my situation, but they're not responding me back, and it's almost 8 months now. Anything I can do?
Okay. Before that, I would like to ask, I mean, have you got any legal advisor, or is this the application you made by yourself, or you had any solicitor or any legal advisor who helped you with
No,
this
I did it
application?
by myself.
Okay. So yeah, I'll pass this. Mr. Shafi would like to.
Yes, thank you, caller. Thanks for your call. This is one of the very important issue, to be very honest. Well, I think lots of applicants have been facing this sort of problem. So basically, you can't do anything at the moment. You can send another chase letter, or you can send an email to them for an for letting you know the current position of your application. If it is a significant delay, you can send a letter before action to them saying that you would lodge a judicial review against them. It's because of delay. But to be very honest with you, your situation and your circumstances and the delay in questions is not that significant in terms of sending a pre-action letter at this stage. I think I would suggest you to send another email and wait for that. If it is like more than 1 year, then I would suggest you to send a letter before action. And if they reply negative, then you may lodge a judicial review on the basis. But the delay in question is not a significant delay, so I would not suggest you to do anything at the moment. But send a formal email asking for the current position of your applications.
I see. Okay,
You're
thank you
welcome.
very much.
You're
Thank you.
welcome.
Thank you.
Bye.
Thank you, Mr. Shafi.
You're welcome.
Yeah, so because of this COVID-19 guidelines is affecting every applications, and obviously there are also like too much pressure with the
Yeah.
home office, because most of them, we all are working from home. So
I think we have to accept the situation at the moment.
yeah,
The situation is such that we cannot blame them. For example, the appointment system is not working. Last few months we haven't got any appointment for our clients. So there is a huge case law for the Home Office to consider. So that is why it's taking time. And I would suggest all the viewers to wait patiently. And they can send the email, they can send letters, but most of the letters are going to their office. They are not in the office, as you said. And most of the officers are working from home. This is a big problem at the moment, but we have to accept the situation. The delays is something. It's not something that unexpected, given the fact that we are in pandemic.
thank you, Mr. Shafi. So yeah, so coming back to the discussion, I mean, as you know, that there is a financial requirement 18,600 for the spouse extension, which is FLRM, and then ILR under the spouse route. So at this current situation, we know that due to COVID-19, a lot of people are suffering with their jobs. Some may have lost their jobs. Some are on furloughs. So I want to know, if someone is unable to meet the current meet the financial requirement at this current situation, how will it affect his application? Will it affect his application, or what option does he have?
So basically, a published Home Office published a guidance back in 2020. So in that guidance, there are two elements. First element is, if you lost your income due to COVID-19 pandemic, then the Home Office will consider the 6 months documents prior to the loss of income. So if someone lost income, then they can rely on their previous 6 months pay slips and bank statement and make an application, and their application will be considered, and as if the Home Office will consider that they got their job and they got their income. So those who have already lost their income, you should make an application on the basis on the published guidance. Basis on the published guidance, make an application with your pay slips prior to your loss of income. And second one is if someone receives furlough, that means 80% of their salary, then the Home Office guidance is they will consider that that person is receiving 100% of their salary. So there is no loss of income at all. So if someone is receiving furlough, 80% of their salary, they can make an application. And if their 100% salary covers the 18,600 threshold, they should be fine. There shouldn't be any problem at all.
Okay. And say, for example, if someone is self-employed, so in that case, I mean, is it the same or how does it work? So say like someone is self-employed.
So before that, I would like to tell our viewers that there is a deadline. So the loss of income and the furlough has to be before 1st of January 2021. But I believe the Home Office will update their guidance again. It's because of the pandemic, and the current situation is worse than the beginning.
Before,
so yeah. So basically they will update their guidance. I think very shortly, and they will extend this. So those are basically self-employed. They can rely on their income of previous year. As you are aware, from this current financial year, most of the self-employed people wouldn't get as much income they had previously. It's because of the COVID-19 pandemic. For example, businessman or taxi driver, for example, they couldn't even do any job in this financial year. So they wouldn't be able to meet the income threshold. So what they need to do, they need to rely on their previous year financial, which is 2019 to April 2019 until April 2020. They have to rely on their financial year. They have to provide all the evidence as required in the Appendix FMSC and make an application under that ground. Year financial, which is 2019.
Thank you so much, Mr. Shafi. I'm just receiving from the back end, they're saying there are too many calls. So let us answer this call and we'll come back to the discussion. Thank you. Hello, good evening. Hello, can you hear me? Hello. Hello, Mr. Ahmed, can you hear us? Hello, caller. Hello.
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 Hello. Hi.
Hi, how are you?
Yeah, I'm not too bad. How are you?
I'm good, thank you. I'll request you if you can kindly please mute the live show which you're watching, and if you can please move to the quiet zone so that it will help us to understand your question.
Yeah, sure.
Thank you.
Yeah. So I have a question, please.
Yeah,
my
sure.
name is Moin. So I came to the UK as a refugee.
Okay.
So and my kids, one of my child is born 2016. She's was applied for his visa, and they give us visa exactly like my visa without writing refugee. So and he's going to back in his home and with his mom. So because his mom came here a year after me, like sponsor visa, and but the problem is my second child, he's born 2019. So and I have applied for his visa exactly same. exactly same writing, everything. So,
Okay.
but on his visa, they write in refugee. So I'm a little bit worried.
Okay, so
Is
you
he
got
can?
the I mean, don't get me wrong. You got the refugee status, yes?
Yes.
Okay, and your spouse, is she under refugee status as well?
No, no, she's on sponsor visa, which
She's
is
on sponsor visa.
we was married
Okay,
before I came here.
okay.
Yeah, that's I fully understood your questions. So you are on a refugee status. So your spouse visa, your spouse application, when your spouse submitted her application to join you as a spouse, so she should have been given 2.5 years leave. Is that correct?
No, they write exactly same as my for 5 years.
So your wife got the visa in line with your leave.
Yeah, same as my expired
Okay.
date.
So the thing is, when you so your dependent will be given the leave in line with your leave. So when your visa is expired, that means their leave will be expired because they are dependent on you, right?
Yes,
So
exactly.
once you complete your 5 years residence, you can make an application. Is called Set P. So you can make an application to become settled in the UK. So what is your question basically? Why you are? What is the main questions?
The main question is that they give my first child visa, like just said, like exactly same as my wife visa. I
Yeah.
cannot see any refugee, and he traveled back to home with his mom.
Okay.
So, but the second child, the visa is exactly same as my expired date visa, but the right refugee, so the refugee live to
So
remain.
that shouldn't be a problem. That shouldn't be a problem for for your wife to travel, But but main
The
thing
child
is
can
when
travel to back to Iran.
yeah, should be. But I need to understand your background. On what basis you make an application for asylum? So if you said in your asylum claim that your family is in risk, then your family shouldn't travel to your home country. But when you make your asylum claim, if you claim that your life in danger, but subsequently your wife join you from your home country, then these are two different things. So when you initially claimed the asylum, did you claim that your wife, your family will be impacted, or if they go back, or
No.
did you?
My family was in Iran when I
Okay,
was applied here,
okay,
and
okay,
then when I get my visa
yeah,
after 6 months, and my
mm,
solicitor applied for the sponsor visa, and
yeah.
she came here without pay anything for visa, or they don't check any
So
income or anything.
your wife was in the UK when you were granted asylum.
No, she was back in
Yeah,
home.
She was
back
in
in home.
Iran, yes?
She was
Okay.
in Iran, yeah.
So did you claim that her life was in danger when you claimed your asylum?
Yes, exactly. But I didn't say anything about my family. I didn't say like my wife is in danger or anything.
Or you didn't say anything about that?
No, I didn't
Then
say.
that should be all right for your wife to travel because there wasn't any issue.
Yeah,
But
she's going every year, but
yeah,
I'm worried
that's not
about my second child.
yeah, that shouldn't be an issue because a child is accompanied by a child's mother. Shouldn't be an issue.
Okay, if there is no problem for indefinite leave to remain, which is
No,
we have to
no,
apply in 6 months time.
no. Only problem is if for example if you travel back to Iran, there is a problem.
Yeah, I'm not traveling. No.
Yeah, so that shouldn't be any problem. So any leave will be given in line with your leave. So if you are granted indefinite leave to remain, subsequently your when your family complete 5 years, they can make an application on that same basis, and they will be granted indefinite leave to remain.
Okay, do I need to mention this to Home Office, like the cover letters, and explain for them?
Now you have to explain the same. You have to provide evidence that you had the situation you had when you claimed asylum, initial asylum, the exactly same situation you have currently. That means if you go back to Iran, your life will be in danger. You have
Yeah.
well-funded fear of prosecution. You have to explain the same thing again. So basically, once your asylum claim was granted, the basis it was granted, you have to have the same basis when you make an application for settlement in the UK.
All right. Okay.
Okay.
Thank you so much.
Thank you for calling.
Mr. Moin, I will advise you to seek legal advice before you apply. So
Yes.
it will help you because your application seems like a little bit. So it's best you seek legal advice before you make the application. So,
Yes, correct.
thank you so much.
Thank you for your help.
Live show. Thank you.
Thank
you, Mr.
I would like to add one thing there for our viewers.
Yeah,
Look,
sure.
we are trying to help our viewers, giving all these informations, but our information is not our advice is not conclusive because we are not in a position to look into your documents. We are not in a position to look into your backgrounds properly because we are not seeing any paperwork. Therefore, please do seek independent legal advice before you take any actions. We try to give as much as information as possible,
Yes.
but
We are
our
giving the
advice
information based on the information they're giving us, which they're sharing us. Yeah, which they're providing us. Yeah, I can understand that. So yeah, I'll viewers like Mr. Shafi, Mr. Solicitor. Solicitor Mr. Shafi, as he requested. So please seek legal advice before you make your application. So for straightforward application, yes, sometimes you don't need. So thank you, Mr. Shafi. Let us go to the next caller. Okay, before we go to the next caller, there are comments. There are a few comments. Let us answer those comments. So I'll go one by one with you. Yes, so it's Neeraj Batra. So Neeraj Batra comment is, hello, sir. I have EU settlement and I'm still stuck in lockdown in Portugal for last 3 months. Is there any limitation to stay out of UK? My settlement valid until August 2025.
Yeah, there is a limitation. You can't away from UK for more than 6 months. So you have to come back within 6 months. But the thing is current situation, you may get some concession from the Home Office saying, given the fact that there is a travel restriction or the pandemic is, the COVID-19 situation is so
if you
serious
provide
now.
the evidence and if you explain, they might take it into the consideration.
And from your comment, what I have understood that you are away from 3 months, so you got another 3 months to come back, so shouldn't be any problem. So you can come back within 6 months.
There are many people like that who got stuck, Mr. Shafi. So
there is a published guidance for the same situation. So those are stuck. They can, even their leave expire, for example, they can make an application for the leave to be reinstated.
I've seen even members saying that the flight has been cancelled. So
yes.
Okay, let us go to the next comment. So that's Irini Agikim. Sorry for the pronunciation. Let us go to the comment. So the comment is, does time spent on Zambrano counts towards 10 years long residency? So I don't know, the comment is not that it says, does time spent on Zambrano counts towards 10 years long residency?
It's a derivative right of residence under EA Regulation 2016. So it's a bit gray area. So just give you an example and give you the reference of the guidance. So if you look into the 10 years lawful residence guidance, it's a clear indication that any time spent under EA regulation will not be counted towards your lawful residency. But if you look into the same guidance where they say they can exercise their discretion and they can take into consideration of that of the time spent under EA regulation. So basically, if you want to make an application under 10 years lawful residence, you can rely on this particular guidance and make an application on that basis. But another thing you need to look into that under EA Regulation 2016, those who were granted under derivative right of residence under Zambrano-Chen principle, they cannot obtain their settlement under Regulation 2016. But if you look into Appendix EU, you can obtain settlement under this under the Appendix EU scheme, settlement scheme. So you have two options: either you go for 10 years route, or you can get a settlement under your current route.
Thank you so much. Thank you, Mr. Shafi. So the last comment we will take is, hello, sir. Is there any limitation for leave of EU passport holder after EU settlement? Actually, I'm out of UK since last 3 months. So I think that's the same question which we have answered previously. Yeah, that's the lockdown in Portugal. Yeah.
So there are, I mean, there are two different things. One is pre-settled status, one is settled status. So those who go settled status, if they are out of the UK for 2 years, their settled status will be basically void. It's no longer will be valid.
So it will be invalid. So that
yeah, if someone is absent from the UK for more than 2 years. So there is a paragraph paragraph number 18 and 20 deal with this sort of thing. It's a returning resident test, right? They have to consider some other aspects, whether the person go connection with the UK and all this. So if someone has indefinite leave to remain or permanent resident or settled status, and if they are out of the UK for more than 2 years, their leave will be lapsed. But I believe the viewers go settlement status. So if he comes back within 90 days, then that would be better for him, because if he has a settlement status, then after 1 year he can make an application for naturalization. So when he makes an application for naturalization, they will consider whether he was absent more than 90 days in last 12 months. So it would be better for him to come back as soon as possible. If no, then I previously answered the same question, similar question, so that one applicable for him.
Okay, I would like to add a question. I mean, as we know, for the indefinite leave to remain and for British citizenship, we require 2 referees. Now, for example, if someone is unable to provide the referees and have submitted the application, so in that case, what Home Office decision will be? Will they refuse the application, or?
Yes, they can. They can. But this is basically a part of procedure. So that the reference detail has to be given. But if someone doesn't have,
so this is like compulsory. Like this is like compulsory. You have to.
Yeah, it's one of the compulsory procedure. A compulsory procedure. But if you look into the Nationality Act 1981, these are all these factors that absence, residence, and qualifying period, and all these factors, knowledge of English, life in the UK, and all these factors. This is a procedure, and you have to follow the procedure. And it's basically I never had any client having difficulty to find a referee for their naturalization application. So
I'm asking because there are a lot of questions. There are people during this current situation who are facing difficulty to find referees, because obviously they can't go and see. So everything. So it's like lockdown. They can't visit the house. They're facing difficulty.
The problem is, there is no such concession given in this kind of scenario. It's because this is not something essential. Like, for example, if my leave is expiring, this is essential for me to make an application, right? But if I have an indefinite leave to remain, so it is not essential for me to naturalize myself within this pandemic time. I can wait for another 6 months or 12 months. So the Home Office will not exercise discretion on these aspects, because it is not something that necessarily to be done immediately.
I understand what you're trying to say. So you can wait until you get the.
You can wait, yes.
I mean, it's like no rush. So
no rush, yeah. And if leave is expiring, then there is a problem.
Yeah, and who can those referees be?
So the first referee has to be a professional person. It could be a teacher, it could be a solicitor, it could be an accountant, it could be a director of a company, it could be a manager of a company. So it has to be a professional. And the second one has to be a British citizen. But bear in mind, they have to have a clean record. If they have a criminal records, for example, then this is going to be a problem.
Okay, if I go with the first one, so say for example, can I make my GP surgery doctor?
Of course you can. It's a professional. Yes, you can. Even you can have a reference from a teacher as well.
Okay. And second referee can be
anyone over the age of 25
who hasn't got any kind of criminal.
Yeah, has to be a British citizen and have a clear record.
Okay. Thank you so much, Mr. Shafi.
You're welcome.
Let us answer another. Yeah. So, hello, caller. You there with us? Hello. Hello, caller. I think they are basically it's through Zoom, so they are facing a little bit of problems to join to the live. So let us go to the next caller. Hello, caller. Hello. Hello, caller. Are you there with us?
Yeah, I am. Can you listen to me? Hello,
yes. Yes. Can you listen to us?
Yeah, I can.
Yes. Yeah. How can we help you?
Yeah, I have a question. Yeah, I can have a question. I came on Tier 2 General Visa in 2016 April, and it was initially granted for 3 years until 2019, and then from 2019 I got another couple of years extension.
So 2016
now,
April, and then 2019 till, yeah?
Yeah, 2019 for another couple of years. Well, I'll complete my 5 years in April this year.
Yep.
Now, my wife came with me as a PBS dependent at that time. So she also got a BRP from 2016 until 2019, and then from 2019 till now. Now, in terms of the absence, my wife was out for more than 6 months during her initial leave to remain between 2016 and 2019. So she was out in 2018 for more than 6 months. But the further extension that we got in 2019, which is now valid, she hasn't crossed that limit. Will that make any difference in terms of her application when we do it for an ILR in April?
Mr. Shafi, would like to answer this?
Sorry, the middle bit I couldn't hear you properly. So your wife was absent for 6 months back in 2019, you said, isn't it?
Into 2018. So the initial leave was between 16 to 19, and in 2018 she was out for more than 180 days.
Okay.
But I guess there was a clause which said, I mean, this 180 days absence clause was initiated for PBS dependent in 2018, but it will be only calculated in your current leave to remain. So if you're absent during your leave granted prior to that change, it won't count. Is that right?
Now, to be very honest, they will count any period of absence in the last 5 years. So any period where you were absent for more than 180 days, that could be counted as an absence. So is there any compelling or exceptional reason for why your spouse or your PPS dependent were absent from the UK? Is there any reasons?
Yeah, it was basically reasons at her family end, but there's nothing in terms of evidence that we could give something like they asked for a hospitalization or things like that. But it was
okay. The best way forward is for you to make an application for settlement, right? And your wife to extend her leave as a PBS dependent. Okay.
Okay.
So even though you will not be tier two migrant, you'll get your settlement, but your wife can extend her leave that you go settlement. She can live under same category, and once she complete her 5 years, where you can exclude the absence of 180 days from that point. If she spend another 5 years, then she can make an application for settlement as well. Yeah.
Okay, but I was going through the publications. There were some exceptions highlighted. So for PBS dependent spouse or a partner, it was saying that there was no absence clause of 180 days before 2018. So you didn't have that 180 days taken into consideration, and it will be effective only not retrospectively. So any leave which was granted prior to that period, since this leave was granted in 2016, will that still count?
Now, if you look into is appendix continuous residence, there's a rules.
Yeah, that's right. Yeah.
Rules. Now, if you looked into it, they said so when you make an application for settlement, they will consider your 5 years residence, right? And they will consider the same for your dependent as well, 5 years residence. And the question is whether you or your previous dependent were absent from the UK for more than 180 days in last 5 years period, okay, in one go. So if she was absent, this is the position. If she was absent, there is a problem. And if you have a reason for that absence, then you can rely on that reason and try to give an explanation and make an application, right? I looked into the guidance today, and it's still the same. So 180 days, okay?
Yeah, okay. Yeah, but I was just referring to that exceptions thing, which said, if you have 2 leaves of grant, you'll only count if there are any absences for a PBS dependent in the current leave granted, which was in 2019. So that's not the case thing.
Now, they will, that's for your extension matter. But when you make a settlement application, they will consider your 5 years residence. And when they consider 5 years residence, they consider whether you were absent for 180 days.
Okay.
Yeah.
Thank you.
All right. Yep.
Thank you, Mr. Shafi. We are now approaching towards the end of our live. So thank you so much for answering those questions. I know there are callers and there are also, there are a lot of questions viewers are having. So Mr. Shafi, as you know that currently, because of this current situation, there is a huge delay in the application. So would you like to say to our viewers, especially those applicants which are over 6 months, so do they have to, how can they get in touch with the Home Office about the applications?
So, sorry, would you be able to repeat this question again, Bhaiya? Sorry, I got some noise from outside.
No, that's fine. I'm trying to say, because of this current situation, there are many applications which are pending with the Home Office, which are over 6 months. I know there is a guideline which says that you need to wait up to 6 months before Home Office before Home Office gives the decision. But say like applications which are over 6 months, in that case, how can they get in touch with the Home Office? Do they have to email them, or they have to get in touch with a legal advisor?
So they can send an email by themselves, or they can ask their solicitors to contact the Home Office. So basically, there is an email address. You can send an email, but it's very hard because we got some email from Home Office, so we try to keep some of the email address safe so that we can send some correspondence to them. So basically, the best way forward is sending them letters. Like, for example, if someone is submitting an FLRM application, so try to send it to Sheffield office. They will look into it. So whenever you send any correspondence, just put your unique application reference number. They will find your application. They will find your application, and they will consider your request. And try to send an email as well if you have an email address, and chase them about. Try to put pressure on them to let you know the current position of your application.
Yes.
This is the only way you can deal. If there is a significant delay, I would suggest some of the clients to send letter before action saying that if you don't give a decision within certain days, then we'll lodge judicial review or something like that. But it's 6 months, even 1 year is not significant delay according to the Home Office. And the 6 months period is basically if there is any complication, they can hold the application for longer than that. So 6 months time frame is not clearly. Plus, during this COVID-19 pandemic, they also say that because of the COVID-19 pandemic, there is taking time to consider some of the applications. So it's taking longer than normal. We have to accept it.
Yes.
We can't put pressure on them to make a decision on this on our.
I understand. There are many people, who wants to travel, who have got like many plans well ahead. So, but end of the day, you can't do much at this kind of situation. So, we will request you to wait. And if you think it's over 6 months, get in touch with the Home Office. You can email them, like Mr. Shafi, he said you can get in touch with them, you can chase them up. If you have got a solicitor, try to get in touch with the Home Office through the solicitor. So thank you so much, Mr. Shafi. I'll take one last comment for this with the last comment of our show. So is Akila Sanjeevi. Her question is, if set LR was applied and biometric is yet to happen, by chance, if they open super priority service before biometric, can set LR application be withdrawn without losing money?
So so if before biometric, I think you can cancel your application. You will get your application feedback, but it will take a long time to get this money back.
Money back,
And
yes.
if you want to go into super priority, to be honest with you, I think there is no scope for you at the moment because they only open for point-based system. So if you submit an application, please continue this because we can't tell you for sure when the super priority will be resumed for all the categories.
There is no update for this super priority for IL application yet.
No. Only point-based system they can rely. They can use super priority service, but other than that, no one can. So we can withdraw the application. You can get your money back, but also you need to look into your current leave as well, whether you go current leave or not. If you cancel, for example, if your leave was, if you made an application at the end of your leave, and if you try to withdraw your application again, that means you may lose your legal status in the UK as well, because your 3C leave will not continue. So there are so many other aspects. We cannot give you advice on this without understanding your proper your backgrounds.
Yeah, thank you so much, Mr. Shafi. I'll request Akila that before you do such decision, please take legal advice, because withdrawing the application, you won't lose your money, but it can take up to like 10 months to get that money back. So think twice before you withdraw the applications. And
there are some consequences as well. So we have to understand her immigration background in order to advise her whether there is any possible consequence.
Thank you so much, Mr. Shafi, for coming to my live show.
You are most welcome.
And thank you so much, viewers, for watching our live show. Those who have missed to watch the full live show, you can see our repeat program on our YouTube channel. I will request you to visit our YouTube channel, subscribe, and share with your friends, and you can watch the live show again. So we are looking forward to be live next week again, same day, same time. And yeah, thank you those who have applied, those who have made the applications. I wish you all the best with your applications. Again, I'm saying you to wait for a while, because due to COVID-19, as you know, this is a global pandemic, so everything is getting a little bit delayed. The visa officers who are working in the home office, they're also working from home. We need to understand that as well. So yeah, so Mr. Shafi would like to say to our viewers in a few words at the very end.
Thank you, viewers, for watching our show, and we tried our best to give information in relation to your questions. And I would suggest everyone to seek independent advice before you make any decision in relation to your any application. So please do take independent advice. We try to advise. We try to give information based on the information you provided. So it's best for you to have a consultation and let someone to look into your documents properly and advise you accordingly. So thank you again. Thank you for watching our show, and hopefully we'll come back again.
Thank you, Mr. Shafi.
You're welcome.